Good afternoon, everybody, and welcome to Churchill Tax Advisors Tax Investigations webinar, the first one of 2021. Happy New Year to all our attendees. We've got a good number of people watching us today, and also if you're watching it on the recording, then again, welcome and Happy New Year to you all. If you've registered for this presentation, you will receive a link to the recording. So today, my colleague Imad and myself are going to talk about some recent tax cases that have been heard and decided in the tax tribunals. Tax cases are important to keep on top of. We as a firm regularly check on decisions that have been made in the tax tribunals because they're relevant to cases, particularly on some investigation angles. Some areas of dispute with HMRC can only be resolved by way of the appeals being heard at the tax tribunals. We have covered in previous webinars the tax tribunal process, and also mediation is another area that can be considered to settle appeals. But ultimately, if a disagreement cannot be settled with HMRC, the only way to resolve matters is through the tax tribunal. So it is important to see what other cases are being heard at the tax tribunals, because those decisions can help or influence your own case. So it is important to keep up to date technically with decisions that are made through the courts, because the revenue equally will rely on cases that support their view, and the revenue might be a bit more quiet when cases go against the revenue and support the taxpayer's view. So it's important as professionals that you keep abreast of cases. So we're going to run through a number of cases that have been decided and heard towards the back end of 2020, sorry, and a couple have come out in January 2021. Can't believe we're in 2021 already. Where does the time go? So without further ado, we'll start the presentation. We've just gone a bit ahead of ourselves there. Go back to the start. So as many of you know, we provide specialist service to other accountants, solicitors, and individual taxpayers and clients. We are experts in Code of Practice 9, the more serious type of fraud investigations, Code of Practice 8, where it's complex, difficult investigations and inquiries, VAT investigations, and even expert witness in criminal cases. So I have over 30 odd years experience in tax, being a chartered tax advisor, and 20 years with the Inland Revenue, HMRC, and ex-inspector of taxes. And I use my experience in the revenue to help and assist clients facing revenue investigations or making voluntary disclosures. So what have we learned from some recent tax tribunal cases? Well, the first one that I want to pick on is a case that involved legitimate expectation. Now, this was a case that probably has very little effect on most people's investigations as far as the specific facts are concerned. It involved a motor dealer and historical VAT claims, and it was quite a complex area around whether a claim could go back to 1973 when the VAT started, and whether they could use a particular system to calculate the VAT refunds. There was an argument around the revenue refusing to give this refund to this particular appellant. But the reason it's important in other cases is because it highlights the difference and the limitations of what a tribunal can hear. So this was a first-tier tribunal case, and they were trying to argue that the appellant had followed HMRC's published guidance. Now, guidance, as the revenue quite often will state in their manuals, and as has been decided and issued in other tax tribunal cases, is not law. Guidance is only the revenue's view. Now, many people would obviously follow the revenue's guidance if it helped them obviously give some element of certainty. But ultimately, you have to turn back to the law to decide on how something is taxed or not taxed. And if you rely entirely on guidance, it won't always help you should the revenue disagree with your point. There are some complex areas around if that guidance is found to be incorrect, then have you as a taxpayer acted incorrectly or not? But the point being of this particular case is, yes, guidance can't be followed. You have to follow the law. But what the appellant was trying to argue here was that the tribunals also had a right or an option to consider whether something was allowable in public law and in EU general legitimate expectation. And the tribunal said no, it couldn't consider public law or guidance. The tax tribunals can only consider statutory law for tax cases, not public law. So public law, or how the revenue administer taxes, is something that for judicial review. So the tax tribunals can't move into or approach judicial review type issues. In some very, very particular circumstances, if judicial review or public law or the administration of the taxes can be shown to have a statutory effect, then it's possible the tax tribunal could consider the administrative side of things. Otherwise, it isn't. The revenue do state in their manuals that everybody has a right to fairness, proportionality, predictability, and certainness. If any of those are disagreed with or fall foul, then the correct approach really is judicial review. One of the other points that was mentioned in this case was the argument that all taxpayers should be treated equally. Again, in law, that does not stand up. There's no precedent to state that everybody has to be treated equally. There is no requirement by HMRC to treat every single case equally. Obviously, the aim is to treat everybody as equally as possible, but it's not always physically possible to treat every single case equally. Each case resolves on its own facts. So the ultimate conclusion from this particular case, which is also a very useful summary of other similar type of arguments around public law, legitimate expectation of what the revenue would normally do on a case, it's worth reading for those points. But ultimately, if you've got a disagreement with the way the revenue administer a case or administer a decision, then it's one for judicial review, which is outside the tax courts. It's public law, and they start off at higher courts, and they're a separate form of legal action. So that's the takeaway from this case, is if you're trying to argue about the way the revenue treat fairness or proportionality, then it's not appropriate for the tax tribunals. It's appropriate for judicial review.
Yes, Dave, on this, this is a very useful case in that it's a very useful point from the perspective of knowing which direction you're going and where to go, what needs to go into the tribunal and what needs to go into judicial review, because in the background you must be putting in a lot of preparation, and you might be thinking, I've got a very strong case, and if you take it to the wrong platform, then the whole thing gets dismissed. So it's very, very important to know what type of arguments would work.
It is, and although the revenue manuals are there for guidance and they're useful to see a view, it's always got to be remembered that it's not impartial. It is generally for the internal use of the revenues inspectors. It's how they judge a case, it's how they consider the situation. They just make their guidance available to the public. It's not aimed at the public, and you always have to bear in mind that reliance on the revenues manuals, although persuasive and can be used in arguments with HMRC, cannot usually be used in a tribunal situation.
Yep.
Not a tax tribunal anyway, maybe judicial review.
Move on to the next case.
Yep, thank you, Imad.
Okay, so this case, the reason we've picked this case is we are seeing a lot of cases where penalties are charged by HMRC, penalties that are charged by HMRC which are deliberate, and we have to then go back and forth with them to argue the point that the penalties are not deliberate and that they should be careless. I'll give a bit of background on this case and then get into the detail of it. This person, Nasser, was running a convenience store. There was an unannounced visit by HMRC that opened the inquiry, and then they went through the normal course of the inquiry, requesting information from the client, from Nasser, and they issued VAT and income tax assessments. One interesting thing in this case was the penalties for VAT are deliberate, but the penalties for income tax were not deliberate. Normally, because VAT and income tax, normally inquiries would be led by VAT and everything would follow, so you would expect similar type of penalties being applied to both VAT and income tax. Now, this appellant was very late in filing his appeal. I think there was a delay of about 410 days. So he submitted an appeal for the 1617 assessments, trying to argue that it was an extension of an appeal that was already existing. So there was already a case for 1314. The tribunal applied the Martland principle, which requires that every case is dealt with. There shouldn't be any undue advantage to any party. And considering the facts that it was 410 days late, it was the late appeal was refused. And another aspect of this was that the appellant's representative, they tried to submit a witness statement as an expert witness. When it was examined, it turned out that he isn't an expert. He isn't someone who can put in an expert witness statement, and he had to withdraw his statement. Now, when the tribunal considered the assessments, they will normally weigh every side of the argument. So what they saw was HMRC had done everything that they can, and their assessments were to the best of their knowledge and to the best of the information that was available to them. And this is one of the things that we say in situations like this. If from our client side there isn't a lot of information, then HMRC can only do their best. They have to rely on best judgment to push forward the case and raise assessment. So it's always important to have as much information as possible. In this case, the tribunal said, well, the appellant really hasn't got any credible information, so they decided that the assessments will stand. Now, when it comes to the penalties, this is where this case is quite interesting in the sense that the tribunal said that for there to be deliberate penalties, you need to show that there was intent on the part of the taxpayer. Now, when they looked at this appellant's circumstances, his record keeping was so chaotic that the tribunal said it's impossible for someone to be able to have a deliberate intention for it to be deliberate. In other words, deliberate requires some element of being organized, and this appellant's record keeping was very chaotic. In the end, the tribunal decided that that the penalties are at best careless and not deliberate, because HMRC were not able to prove deliberate intent.
Yes, thank you, Ahmad. It is a useful case to, again, to highlight the difference, I suppose, between someone who's deliberately acting to defraud the revenue and somebody who's just a bit rubbish at their record keeping. The revenue have to prove deliberate behaviour. The onus is on them to prove that someone has acted deliberately, and they would usually ask questions or investigate or understand what's happened. Obviously, the worst case end of fraud and deliberate behaviour is someone creating and falsifying documents. I think if you do that, then obviously it's a slam dunk, as the technical term, that you're going to be found guilty of fraud and deliberate behaviour if you falsified documents or taken action, obviously, to defraud HMRC. But in other circumstances where you've got into a mess, then it may not have been intentional. It may have been more careless. And what can be a grey area is just how reckless someone might have been, and the revenue obviously will come down quite strongly if they think that someone has been very, very reckless and bordering on deliberate behaviour, as opposed to careless and making mistakes. Useful case to bear in mind.
Yep.
So this next case, Robert Osborne, is I suppose one in a million case almost. That was decided in the taxpayer's favour, because there have been a number of claims for dual purpose expenses. So that is where a cost, an expense in a trade, has more than one purpose. And the most famous case that's always been the precedent-setting case was the judge who sat in court and tried to claim their gowns and clothing, etc., for business expenses. It was decided in that case, Mellor, Lerve and Drummond, that the clothing had a dual purpose of keeping someone warm and decent, as opposed to what was required in the purpose of their trade. So it was disallowed. Expenses, as most of you will know, have to be wholly and exclusively for the use of the trade. So if there is any element of that expense that is not wholly and exclusively, it's for something else, a private issue, a private matter, then it's going to be disallowed. If an expense can be apportioned between business use and private use, then you might be able to agree with the revenue a proportion of use which can be claimed. Again, it's quite rare in those circumstances. The revenue are very, very robust at refusing claims that have a dual purpose. So this case, which was a diver, now a saturation diver, apparently is a deep sea diver who stays underwater for long periods of time, a week or 10 days or so, to do their job, do their work. And the reason they stay below the water for longer period is to avoid the bends of going up and down for deep sea, and obviously getting quite ill or risks of death even in that scenario. But to be a saturation diver, somebody who stays underwater deep sea diving for a long time, they have to be extremely fit. And they had a specific fitness regime, a specific fitness course, which had to keep them in tip-top condition in order to maintain their ability to safely dive for long periods of time for their work. Now, the judges, the decision was that this did not have a dual purpose. The revenue's argument was the fitness training had a dual purpose of keeping them fit in general life. So it kept them personally fit. It wasn't just for their job. The tribunal decided that the fitness regime was so specific to their trade that actually it wasn't really benefiting them personally. The only reason they did it is for their job, to enable them to safely undertake the deep sea diving. So the appeal was allowed against the revenue's view. So it is quite a one-off case. I don't think it's going to set any major precedents for other people. It will depend on its facts, but it does still show that the tribunal will consider if you can prove that an expense is wholly and exclusively, or if there is a dual purpose, the private element is tiny or very minimal, then you may well succeed in a claim. What the judge did also point out, though, is if you were an employee, you probably wouldn't have that claim successfully allowed, because as an employee, you've got the extra hurdle of it being necessarily incurred. And that means that basically all employees in a similar scenario would have to claim the same type of expense. It's not just wholly exclusively, it's also necessarily in the performance of the duties. It's far harder for employees to get expenses claims allowed by HMRC than it is for a self-employed trader incurring similar expenses. So the judge did say if that diver had been an employee, they probably wouldn't have had the expenses allowed.
It's a very interesting case, and one in a million, like you said, because certainly in dealing with HMRC and in cases around expenses with dual purpose, they are very, very strict. And the interesting thing about this case is I guess the appellant had to go to extra lengths to be able to show that this fitness regime was very, very specific, and that if he didn't have this this trade, then he probably wouldn't be required to do that sort of fitness regime. And I think it's especially for employees, you're absolutely right. HMRC are even more strict when it comes to allowing expenses for employees. So, like you said, it does show that it's not always the case that it's completely all expenses are just completely disallowed. There can be an element, but you have to be able to demonstrate it very, very clearly.
Yes, and he provided a lot of evidence and documentation to show what his fitness regime was, and certainly I wouldn't fancy doing that fitness regime. But then again, I probably wouldn't fancy being a deep sea diver either. Thank you, Ahmed.
Okay, now this one is a case where there was personal liability notices issued. Now, the reason we've picked on this case is because there can be instances where people think that if there is a liability on the company that they're working with, they can just simply put the company into liquidation and forget about it, because HMRC can then chase you personally. They can transfer the liabilities on to your person and chase you in your personal name for the amounts that are due. Now, I'll give a bit of background on this case. So this is a case where they've been submitting in VAT returns on cash accounting basis when HMRC had told them clearly that they cannot be using the cash accounting basis. The company, the appellant, Mr. Robinson, his company was PMR, that was providing project management services, and he was invoicing two companies. One was the development company CDW, which was set up for the development of flats, and there was another company CED, which was set up to obtain finance. Mr. Robinson would invoice these two companies, and these two companies were also registered for VAT. Now, they would claim input VAT, and this was allowed by HMRC. It was authorized but not paid. This is an important point. It will become clear just moments later. Now, once the VAT returns were submitted, inquiry was opened, and HMRC made the point clear that you cannot be, to Mr. Robinson, you cannot use the cash accounting scheme. He said that's fine, but I will need time to cease, basically move from cash accounting to accruals, the normal VAT returns, because of cash flow issues. What happened after that was HMRC started issuing notices, assessments and penalties, and then there was a bit of chaos from HMRC side, in the sense that sometimes assessments were issued, cancelled, then issued again. The reason HMRC issued deliberate penalties was that the appellant had submitted tax returns, incorrect returns, VAT returns, knowing that HMRC had told them not to submit cash basis. What the appellant went back and said was that because HMRC had allowed input VAT to be claimed for the companies that he was invoicing, there was tacit agreement on HMRC's part for the appellant to be able to use the cash accounting scheme until he's able to sort out the financing. What the tribunal said, again, with deliberate penalties, the burden of proof is with HMRC. Now, in this case, the burden of proof was with HMRC to demonstrate that there wasn't this tacit agreement. And the tribunal said that on balance of probabilities, HMRC failed to demonstrate that there was a deliberate inaccuracy. From the appellant's side, he had maintained one position from the very beginning, that he needs time to switch away from cash accounting. But from HMRC's side, I think where they lost the case, the appeal was allowed, and the penalties were not held as deliberate. Where they lost the case was because they kept changing, in my opinion, they kept changing the position. So that's where the appellant is able to show, well, their position is not clear. I've been clear from day one. So it's just, it's an interesting case. Normally, if HMRC would have maintained their position and not reissued assessments and notices, we might have had a different decision, and the deliberate penalties would have been upheld.
Yes, as you mentioned, Imad, obviously the important point here is that the revenue were contending to switch and charge the penalties on the director personally following the insolvency and liquidation, and saying that he was at fault for the business. So insolvency, liquidation doesn't always get rid of the problem, but the revenue have to be able to prove and show that the director had been acting deliberately in order for them to charge him personally, and that's what they failed to do in the tribunal. With this and other cases, you never know if the revenue are going to appeal the decision. They may still disagree and think that their case is stronger, and this and other first-tier cases could be appealed to the higher courts. And obviously, it's worth keeping track of particular cases that you're interested in to see where they develop or whether they end up being closed and finalised.
Yeah, I think the most important point is, because we see a lot of people and you speak to them, and sometimes there is this idea that, okay, if there is a liability in the company, I can just put it in liquidation and walk away. It does not always work like this, because HMRC have the powers to be able to transfer it into on your name personally. So it doesn't sort of liquidation doesn't always address the question, or it doesn't mean that the problem has just gone away.
Indeed, and if you're interested in more detail about that, please see our previous webinars where we've had some guest speakers around insolvency and the effect on directors. it's not, you can't always walk away from responsibility or liabilities, and especially now with changes to joint and several and other ramping up of the law again in the revenue's favour. Our final case today involves a change of law a number of years ago, which was aimed to speed up and resolve complex cases. So normally, for a case to be closed and finalised, the revenue would have to issue a closure notice on their inquiry, which might be a closure notice on a company return, it might be a closure notice on a self-assessment tax return. That would have to cover all the points of the investigation, all the points that were in dispute. With some complex issues and maybe tax avoidance, or in this particular case to do with residence and domicile and remittance, if those complex points are going to go on for a long time, but other areas, other issues have maybe been settled, the revenue campaigned to change the law, and the law was changed a number of years ago, which then allowed the revenue to issue partial closure notices. So that meant that you could bring to a head a particular point. So if, say, on a self-assessment inquiry, you have 5 points that have been opened for that investigation, 3 or 4 of those points have been settled, 1 point is outstanding, the revenue can issue a partial closure notice to settle those 3 or 4 points that have been agreed. And you could have you could then maybe settle on a contract basis, or obviously you settle on a closure notice and pay that liability, and that then is finalised. You can move on then and continue with the open point. Equally, if you've got 4 or 5 points that are open in the investigation, but one of them is contentious, and in order to move the case forward, you need to resolve that point at an appeal or by way of a tribunal, then again, the revenue can issue a partial closure notice for that particular contentious point, and then that partial closure notice can be appealed. That appeal can go to the tribunal. You can then resolve that particular point rather than having to wait for all the points to be resolved and a full closure notice issued. The point in disagreement here was about the validity or what needed to be done on a partial closure notice. This taxpayer had claimed to be non-domiciled and was claiming the remittance basis. The revenue didn't accept that and inquired into the domicile status. They issued a Schedule 36 notice requesting information. The taxpayer had applied to the tribunal for a partial closure notice on the domicile point without having to give all the information to HMRC. The taxpayer's argument was the revenue can issue a partial closure notice on a point of principle around the domicile. The revenue's view was no, they couldn't. They could only issue a partial closure notice setting out the amount of tax, and they could only set out the amount of tax when they knew all the facts and the information. The taxpayer wasn't prepared to send that information before the domicile situation had been resolved. So ultimately, the parties were just stuck in disagreement. The revenue couldn't issue a partial closure notice, and the taxpayer was not going to provide the information until the issue had been resolved. So obviously it ended up at tribunal. The first tier decided in the taxpayer's favour and said the revenue can issue a partial closure notice without specifying the amount of tax at stake, and therefore the first tier also upheld the client's appeal against the Schedule 36 notice. The HMRC appealed against that decision, and the case was heard recently at the upper tribunal. The upper tribunal have overturned the first tier's decision and sided in this case with the revenue. They have said the revenue are quite right. They can only issue a partial closure notice stating the amount of tax at stake, the tax at issue. And it's that would then be under appeal, the amount of tax. And therefore, the Schedule 36 appeal was also dismissed. So no doubt either the taxpayer is going to have to supply the information so the revenue can consider if their view on domicile prevails, there will be X amount of tax to pay, and the taxpayer can then appeal against that, or the taxpayer may well seek leave to appeal to the Court of Appeal to take this case further. So although the circumstances are very, very specific to this taxpayer, the point that's relevant to everybody else is that if you are looking to get a partial closure notice in order to settle part of an investigation, it can only be issued, according to this case anyway, which follows the tax law, that the revenue have to be able to give an assessment for the amount of tax at stake. Now, sometimes the revenue might issue or be prepared by agreement to issue a large figure in the worst case scenario, which then obviously can be appealed. But in some circumstances, the revenue can't, they have no idea what that worst case scenario might be. And just issuing an estimate by the revenue doesn't solve the problem either. There have been tax cases which show that the revenue's estimates have to be reasonable and in accordance with information they hold. It can't just be a finger in the air guess. If they did that, you've got a strong case of appeal and grounds again. So that doesn't solve the situation. So it's a useful case, I think, which is going to make partial closure notices need to be specific and can't be issued until you get to a position where a decision can be made one way or the other. So they're my contact details if you've got questions about investigations. We will come to Q&A. If you've got any questions, has Imad's contact details as well here at Churchill Tax Advisors. So we will now go to questions. If you've got any questions, please type them in the chat box at the bottom and we'll try and answer as many questions as we can. We've got 5 or 10 minutes to go through some questions. Let's see what questions we have. We've got 1 or 2 questions here that have come in. Thank you very much. One of the questions is, does a first tier decision set a precedence? Well, the quick answer is no, it doesn't. The first tier by its name is the first tier, so it doesn't set any precedence against any other case whatsoever. It is, however, persuasive. So first tier decisions can be quoted in arguments. We use them to support our case. The revenue use them as well to support their case. They are persuasive, but they don't set a precedent because they don't hold other people to it. If you go to a tribunal and quote another first tier case, again, the judge doesn't have to follow it, but they may be persuaded by some of the reasoning in that case. It is only when an appeal goes to the higher courts, the upper tribunal, Court of Appeal, or the Supreme Court, then a decision in that higher court does set a precedent to the lower courts, or sets a stronger precedent in other cases of investigation. So no, a first tier doesn't set a precedent.
It just on that question, it doesn't set a precedent, but like you said, we have been using these decisions in our cases. They can be persuasive. It's just how you go about it and how you analyze the case and how you present it to HMRC. But it certainly doesn't set a precedent, like you've said.
Yep. And another question we've got come in. Thank you. If a court decision changes a position, can I reopen my previous settlement? Well, again, the quick answer is no. Sorry about that. If you're building your hopes up there, you've seen a case, maybe even one of today's cases that you've seen. You think, well, my situation was identical to that. Can I go back and argue with the revenue? This case has been decided in my favour. I was wrong to settle my case. Can I reopen it? No, you can't. There is no grounds for reopening a case decision, a court decision, only applies to the future or to existing open inquiries or open cases. So if you've got an appeal that's paused or stayed behind a case, then obviously that will then turn on the decision. But if your case has been settled, you've signed the contract, you've not appealed against a closure notice, etc., and you've paid the money, settled with the revenue, a new case that comes along later with a different view doesn't reopen your case. You've no rights to reopen it whatsoever. The only possibility is if there's been some sort of total error or mistake or some bad judgment or you've been prejudiced against. There is some scenario or there's it's a total falsification of a decision. But again, that's going to be extremely rare and extremely difficult. Once a case is settled, that's it, done and dusted. If you think there's another case that's very similar going through the courts, then don't settle. Wait for that case to be heard, and then you'll be able to use it. Nothing is retrospective in court cases. Generally, the law is not usually retrospective either. However, in future years, in recent years, we have seen some legislation come in that's been retrospective, such as the loan charge, which is argued to be retrospective. One or two other allowances and claims have been retrospective, and the revenue go back. That's been written in law to be retrospective. The courts are not retrospective. We've got a couple more questions. We'll briefly pick one on these. What happens if I'm late for filing an appeal with the first tier? You're on mute. You're on mute.
Sorry, can you hear me now?
Yes.
Yes. Before I answer what happens, I would say, please, if it's possible, you shouldn't be late. So where we are looking at cases which is outside tribunal and there's an investigation open with HMRC, let's say sometimes there's delays in sending letters to HMRC by a few days because information is not received, that's okay. Because you can always communicate with the inspector and there will be understanding of the situation. When it comes to tribunal deadlines and filing the initial appeal, it is very, very important to ensure that you just get it out of the way. Because what happens if you are late, a few things. Because in the current situation with COVID, they are giving some extensions and there is a bit more leniency. But what we have seen in the past is if you are late, then the other party, which is HMRC, has the right to object to your late appeal. And then instead of having a hearing for the actual case, you have to spend time and resource trying to justify why your case should be heard. So it's a case within a case. You have to first win the case of being allowed to make an appeal, and then you can actually appeal. Now, the case that I was covering, that person was clearly, the word chaotic summarizes the way he's dealt with the situation. He was late by 410 days. That's a significant delay. Even in cases where the delay is a lot less, there's a lot of, you just have to go through so much just to justify why you can appeal. So you will, with COVID, in short, the short answer is because of COVID, HMRC can take a more lenient approach. They might not object to it, but if they do, then you're in for a bit of a struggle in the sense that you have to have a case for the appeal to be allowed, and then you can actually have the actual case heard. So in short, try and stick to the time.
Yeah, good advice, Imad. We've got one more question we can cover, and then we need to wrap up. And that's if the revenue do quote a decided case that's similar to mine, am I forced to accept the situation? Am I forced to back off and back down and say, well, okay, that's the issue I've got to settle? Sorry about the beeps coming there. No, you don't is the very, very quick answer. But obviously, if your case is very, as we've said before, if the case is very similar to another case that's been decided, then you're going to have to distinguish your case on the facts. You're going to have to either say there are some scenarios that are different to that case, or you're going to have a different argument, a different view. If it's a first tier, it doesn't set a precedent, it is only persuasive, but obviously if you go to the tribunal, you've got to persuade that new judge that your case is different and why yours should be decided in a different way. If the facts can be found to be different, then obviously that is going to be helpful. If a case is higher than the first tier, then you're really going to struggle. You're going to have to get past the first tier and then leave to appeal to the upper tier, and then still argue that your case is different. So yes, if your facts are identical to a decided case and the revenue quote that case in support of their argument, you're going to have to find a good differential or another case that supports your arguments in order to persuade the revenue that actually the case they're quoting isn't the strongest case. It's all down to fact and degree and argument, and which is more persuasive than another. So yes, it can be extremely difficult to overturn your own appeal if it's similar, but you don't have to accept that everything is lost just because a case has been decided a certain way, but it's going to be an uphill struggle. So that's all we've got time for today. Thank you very much for all of your questions. Thank you for watching and listening. In 2 weeks' time, our colleagues on the tax advisory team have a webinar. Please join that one. We will be back in a month's time for the latest tax investigations update. Until then, keep safe, have a good time. If you've got any questions and queries, please do contact us.
Thank you.
Thank you. Goodbye.
Bye.